in the Supreme Court of Judicature of Jamaica, the probate division. We have our claim number here. This is between Horace Richards, the claimant, one who filed the claim, and Geraldine Ramsay-Facey, the defendant. In chambers are Carlton Williams, instructed by Williams, McCoy, and Palmer for the claimant. So Mr. Richards, his lawyer is Carlton Richards from the law firm William McCoy and Palmer, and Mrs. Ramsay-Facey's lawyer is Althea Grant for the defendant. It was heard on December 17th, 2020 and February 19th, 2021. This is an application for revocation of grant of letters of administration. Okay. Introduction. The claim before me was brought against the defendant. That's against Mrs. Ramsay-Facey in respect of a grant of letters of administration which was given to her in the estate of Everald Ramsay in a fixed date claim form filed on the 10th of December 2018, supported by an affidavit. The claimant seeks the following orders. Okay, but before I go any further, I looked up the meaning online of the letter of a grant of administration. Here it says there are two types of grants of letters of administration. One is a grant of letter of administration with the will annexed, and simply a grant of letter of administration. A grant of letter of administration with the will annexed is applied for when the deceased person has left a will, but the executor nominated in the will to not act in that role for any reason, rather than the executor being granted probate. The person applying will be appointed administrator of the will. When an administrator obtains letter of administration with the will annexed, they are still bound to dealing with the estate in accordance with the will. A grant of letter of administration is applied for when the deceased person died intestate, that is, without a valid will. The person applying will be appointed administrator of the estate and will be bound to dealing with the estate in accordance with the law. When a person dies without a valid will, then their estate is generally distributed in accordance with with Section 14 of the Administration Act 1903. Alright, so here Mr. Richards is applying for a grant of a letter of administration. So here again, I read this part again. The claim before me was brought, that's the judge in chambers, Hutchinson, was brought against the defendant in respect of a grant of letters of administration which was given to her in the estate of Everald Ramsay. So Everald Ramsay died. He did not leave a will. The the grant of letter of administration which was given to her. She got the letter of administration in a fixed date claim form filed on the 10th of December 2018, supported by an affidavit. That's a signed document which she signed. The claimant seeks the following orders. 1. The revocation of the grant. So Mr. Facey wants that grant to be revoked. 2. The reversal, setting aside of any action and or acquisition done and or taken by the defendant in contravention of the device under the will. Oh, there is a will there. Okay, so the fact that there's a letter of administration already, it means that the deceased had left a will. Mr. Ramsay left a will. The cost to the claimant, that Mr. Richards wants cost paid to him, and any other orders as this honorable court deems fit. Okay, so that's the case here. It seems as if maybe it's Mr. Ramsay's father or some other relative who died, left a letter of administration so that she will be the executor of his estate, but Mr. Richards wants that letter of administration to be revoked from her. Now, if you find yourself in a situation like this, where you and probably other family members might find yourself fighting over the estate of a deceased person, then some of the information here that we will see in this case would be useful to you. Let's continue. It was noted that there was no particulars of claim filed in keeping with Rule 68.55 4A, there being no objection to the matter proceeding. I opt to treat with it as commenced in keeping with the requisite format. Now, what is a particular of claim? Since the judge says there was no particulars of claim filed. The particulars of claim, I looked it up online. It provides the claimant's statement of case in personal injury or clinical negligence claims. They set out the factual and legal basis upon which the claimant is seeking to claim against the defendant. Okay, so Mr. Horace Richards did not file the particulars of claim stating why he is applying for the revocation of the documents, and he did not claim any injury that would occur to him if this was not done, or as justification for his filing this claim for the grant of letter of administration. Right. The background to this claim was found in an application of letters of administration and will annexed, which was filed by the claimant, Mr. Richards, in the estate of Everard Ramsay on the 21st of April 2015. So Mr. Everard Ramsay had made that will in 2015. That's the deceased. made that will before he died. It's important that you make your will, but even after making that will, it does not erase all of the problems that your estate will might face. The claimant is the son of Mabel Ramsay, the late widow of Everard Ramsay, and the executor in Everard's purported will. So, here, Mr. Richards is the son of the late Everard Ramsay's widow. Okay. But it did not say that he was not the son of Mr. Ramsay, but he was the son of Mr. Ramsay's widow. Okay. Mr. Ramsay's wife at the time. So Mr. Ramsay was his stepfather and executor in Mr. Ramsay's purported will. Mr. Richards sought to make this application by virtue of his rule as administrator in the estate of his mother. In the course of the application, Mr. Richards was informed that a grant of letter of administration had already been made to the defendant on the 21st of October 2016. So Horace Richards, the son of the late Everard Ramsay's widow. Not Everard Ramsay's son though, but Mr. Richards was his stepson. And Mr. Richards made the will so that Horace Richards, his stepson, was the executor of the will. So, Mr. Richards sought to make the application by virtue of his role as administrator in the estate of his mother. Okay. In the course of the application, he was applying, right? He was applying, sought to make application for the letter of administration. But while he was doing that, he found out that there was a grant of letter of administration already. And it was made on October 2016 on the basis that Everard Ramsay had died interstate. So, okay. So it seems as if Mr. Richard's mother died and Everard Ramsay also died, but Everard Ramsay did not leave a will. Okay, let's see. Interesting. So it seems as if Miss Geraldine Ramsay-Facey is the daughter of Everard Ramsay, and she got that letter of administration already. The matter was heard on the 7th of December 2020. On that date, it was indicated that by both attorneys that they did not intend to cross-examine the affairs in this claim and were content with the court coming to a decision on the basis of the evidence contained within the documents filed. This position was probed in light of the issue to be determined and orders sought. Okay. The attorneys maintained their position and the matters proceeded with the affidavits, exhibits, and all other documents forming a part of the record being considered by the court, after which submissions were made by respective counsel. The respective cases are summarized below. Okay. Clament's case. That's Mr. Richards, Horace Richards' case. Mr. Richards stated that he was the stepson of the late Everard Ramsay, as his mother had gotten married to Mr. Ramsay, to Everard Ramsay, while he was still an infant. Okay. He stated that Mr. Ramsay had raised him as his son and always treated him as a child of the marriage. In respect of the estate in dispute, he said that in 1961, Mr. Ramsay purchased the property at Herring Lane, Old Harbour, in the parish of St. Catherine from Sarah Walters, and this property became their family home until the time of his stepfather's death on the 21st of April 2006. He said that following the death of his stepfather, he and his mother remained in occupation until her death on the 27th of April 2009. So Mr. Ramsay died, his stepfather died in 2006, then his mother died in 2009, when he resided alone on the property. Okay. He denied that the property had been purchased by Percival Ramsay, the father of Everard Ramsay. He denied that the property had been purchased by Percival Ramsay, the father of Everard Ramsay. Okay, so Percival Ramsay was the father of Everard Ramsay. But there was some claim that Percival Ramsay was the one who bought it. That would be his stepfather's father. And the defendant, that's Mrs. Ramsay-Facey, the father of Everard Ramsay, and the defendant. So Mrs. Facey's father is Percival Ramsay, and she's saying that it was Percival Ramsay who bought the land. But Mr. Richard is saying no, it was his stepfather who bought the land. Who bought the land. So, and the defendant, that's Miss Ramsay-Facey, and asserted that the defendant, Mrs. Facey, had no rights or interest in that property. He stated that it was not true that Percival had informed Doreen Martin that the property had been purchased by him as at the time of Percival's death with Doreen, when Doreen was still an infant. So in those old days, they didn't have documents when they purchased land. They probably just gave the landowner some cows or other animals or other property, showed them the border marked by some large tree or stone wall or so, but they did not sign documents or use any attorneys and so on. So this here is in dispute without any documents there to show. Alright. So Mrs. Ramsay is saying then that her father was the purchaser of the land. But Mr. Richards is saying that his stepfather purchased this land. He stated that in the event that Percival Ramsay had been the purchaser of the property, then Everard Ramsay had become the owner by way of adverse possession. That's true. So if Mr. Percival Ramsay had been the purchaser, the land would be brought down to his son, Everard Ramsay, and Everard Ramsay would have been the owner by way of adverse possession, having resided there in exclusive and undisturbed possession to the death of Percival in 1983. So Mr. Everard Ramsay would be the owner by adverse possession because of how long he had been living there. So, you see, if you have been living there on the land for an extended period of time, undisturbed, then you would become the owner by adverse possession, and you can apply to the court for a will. So, prior to the death of Percival in 1983 and until his own passing, that's Everard Ramsay's passing in 2006, and had acquired the relevant rights of ownership which he sought to dispose of in his will. Okay, good. Mr. Richards denied that his stepfather had suffered any illness that would have rendered him incapable of giving instructions for the preparation of a will or of signing the same. Okay, so he's saying that Mr. Richard, before he died, signed the will and understood what he was doing. He denied the assertion of Mrs. Ramsay-Facey that her niece, Doreen Martin, that Mr. Everard Ramsay, the latter, had resided at the house of the deceased from 2003 and had been his main caregiver. So Mrs. Ramsay-Facey and her niece are telling the court that Everard Ramsay had only resided there since 2003, 3 years before his death. So he would not have been the owner by adverse possession. He stated, so here, what this is saying, is that if you find yourself in a similar situation and you have been residing on the land or in the house of an elderly person for many years, it is important that you make a record of it, signed by attorney at law or justice of the peace. You state that you have been living on the land undisturbed since a particular date, and each year you add 1 year to it, so that if you have to find yourself in front of a court, you having to attempt to claim ownership by adverse possession, then you would be backed up by documents, right? Instead of word of mouth and other people saying this and you have to be saying that, right? You need evidence. All right. He stated that there was no need for such an arrangement as his mother had still been alive and in a position to care for his stepfather. He contended that while his stepfather had suffered a brief bout of illness, he had fully recovered from this prior to the making of his will. Okay. So here, but when they said this, he contended that while his stepfather had suffered a brief bout of illness, it seemed as if Mrs. Ramsay-Facey and her niece are trying to say that Mr. Ramsay was sick before he signed the will, and the sickness rendered him unable to understand what he was signing. But Mr. Richards said that it was only a brief bout of illness and he fully recovered before he signed his will. So here, it seems like a statement from a doctor would also be good, right? getting a statement. So here, you might find persons who present to the court that someone was not understanding what they were signing when they signed the will because they were sick. So it seems as if what you need to do is get a statement from a doctor whenever the person is sick, so that when they sign the will, the doctor can state that the person knew what they were signing. So your opposition would not be able to use that against you in the court. Here, where was I? He acknowledged that Anne-Marie, the sister of Doreen, had resided on the property, but stated that it was in the capacity of a tenant, and she had rented a structure on the land which she operated as a bar, but it had subsequently been closed down and the location given to Joseph Brown, the operator, to operate as a church. Okay. So here now, it seems like now, if you have an elderly family member and have been living in that house for a very long time, get them to sign a will. Get a doctor to state that they knew what they were doing, they were of mental capability when signing a will. And if any other family member want to come there to sleep or to rent a room or something, do what you can to keep them away, because they could very well use that against you in a court in the future when they are fighting for part of the estate of the deceased. Now, he insisted that the will was valid as it had been prepared at his stepfather's instruction, and the attesting witnesses were well known to him. He stated that it was Everald who had granted Joseph Brown permission to operate the church on his property, and Felicia Brown is the pastor's relative. He denied that the will was a fraudulent document and insisted that it reflected the intention of his stepfather to leave the property to his mother for her lifetime, and on her death to him absolutely. So Mrs. Ramsay-Facey and her relatives are saying that their mother, right, was the right owner, would have inherited the land, because Mr. Richard's will was fraudulent, and he told them that he was leaving the land to his mother, to his wife, which would be Mrs. Ramsay-Facey's mother. But Mr. Richard is denying it. So here, every statement must be documented. It cannot be back and forth saying one said this and the other said that, and so on and so forth. Everything must be documented and signed. All right? Signed by a justice of the peace or an attorney at law or some other person. Mr. Richard relied on the joint affidavit of Joseph and Felicia Brown and attesting witnesses in which they deponed to being present together for the signing of this will by the deceased. Good. It's document there. They stated that the document was read over by the deceased in their presence after he signed and they signed as well. Good. So that's the will. That's a document, signed document, that no one can use their mouth, their words, to invalidate. We will look at the defendant's case in our next video.